More than 60% of UK families unknowingly break a crucial elderly care rule, and some end up paying over £15,000 in unexpected legal costs. Sounds shocking, right? What's even more surprising is that many of these families believe they were doing the right thing to protect their loved ones. But here's the twist. A simple decision, like gifting money or transferring a home, can be seen by authorities as deliberately avoiding care fees. And once that happens, councils can step in, reverse your actions, and hit you with serious financial consequences. So, what is this rule that catches so many families off guard? And more importantly, how can you avoid making the same costly mistake? Stay with me, because what you're about to learn could save your family thousands. Number 10. Ignoring professional legal advice. This is where many families make their most expensive mistake. They rely on guesswork, online tips, or advice from friends, instead of consulting a qualified legal expert. It might feel easier or cheaper in the moment, but when it comes to elderly care laws, even a small misunderstanding can lead to serious financial consequences. Here's the reality. UK care laws, especially around asset protection and deprivation rules, are complex and constantly evolving. What worked 5 years ago may no longer apply today. Without proper guidance, families often make decisions, like transferring property or gifting savings, that seem harmless but are later flagged by local councils as intentional avoidance. And once that happens, reversing the situation becomes incredibly difficult. Now, studies and legal case trends show that families who seek early professional advice are far less likely to face penalties. Why? Because a specialist can help you structure your finances in a legal, transparent, and compliant way, protecting both your loved one's care and your family's wealth. So instead of risking £15,000 or more in avoidable costs, think of legal advice as an investment, not an expense. A single consultation could save you years of stress, disputes, and financial loss. Ask yourself, would you rather pay a small fee now or a huge price later? If this opened your eyes even a little, drop a safe in the comments so we know you're protecting your family the right way. We put real effort into bringing you valuable insights like this. So hit subscribe. It's just one click, but it helps us keep these videos coming for you. Number 9. Overlooking local council assessments. One of the most overlooked yet critical steps in senior care planning is understanding how your local council assesses finances. Many families assume the rules are the same everywhere, but that's far from the truth. Each council in the UK has its own interpretation and approach when it comes to evaluating assets, income, and care eligibility. Here's where things get risky. You might believe you've planned everything correctly, transferred assets, managed savings, or arranged care. But if your local council views those actions differently, you could still face unexpected charges or penalties. In some cases, councils may even challenge past financial decisions, especially if they suspect deliberate avoidance of care fees. What makes this even more complicated is the lack of awareness. Most families don't realise they can, and should, request a formal financial assessment early on. This assessment gives you a clear picture of where you stand and what the council expects, before it's too late to make changes. Experts strongly recommend engaging with your council proactively, not reactively. By doing so, you gain clarity, avoid misunderstandings, and reduce the risk of sudden financial shocks. Think of it this way. Would you rather guess the rules or know them with certainty? Taking this step early can mean the difference between peace of mind and a costly surprise that could have been avoided. If this helped you see things differently, comment "aware" below. We read every single one. We put serious effort into making these videos valuable for you, so take 1 second to subscribe. It truly helps us keep going. Number 8. Delaying financial planning until it's too late. This is one of the most common and costly mistakes families make. Everything feels fine, so planning gets pushed aside. After all, no one likes to think about future care needs. But here's the harsh reality. By the time care becomes necessary, many of your best financial options are already gone. When planning is delayed, decisions are often made under pressure, during a health crisis or sudden decline. In these moments, families rush to move assets, transfer property, or rearrange finances, hoping to protect what they can. But unfortunately, councils are trained to spot these last-minute changes and may interpret them as intentional avoidance. Research and legal case patterns consistently show that early planning leads to better outcomes. Families who start preparing in their 50s or early 60s have more flexibility, more legal options, and far less risk of penalties. They can structure assets in a way that is both compliant and protective, rather than reactive and risky. Think of it like this. Would you rather build a safety net slowly over time, or try to fix everything at the last minute when it's already too late? Starting early doesn't just protect your finances, it gives your entire family peace of mind and control over the future. If this made you rethink your plans, comment "Plan Early" below. We'd love to hear from you. We put a lot of effort into these videos, so please take a second to subscribe. It's just one click, but it helps us keep bringing you valuable content. Number 7. Assuming the family home is always protected. This is one of the biggest myths families believe, and it can lead to very costly surprises. Many people assume that the family home is automatically safe from care costs, no matter the situation. But the truth is far more complicated, and misunderstanding this can put your most valuable asset at risk. In reality, whether a home is included in care assessments depends on several factors, like whether a spouse still lives there, the type of care needed, and the timing of decisions. For example, if a person moves into full-time residential care and no qualifying dependent remains in the home, its value may be counted as part of their assets. Here's where families get caught off guard. Some delay planning, thinking the house will always be protected, only to find out later that it's subject to means testing. Others attempt to transfer ownership too late, which can then be flagged as deliberate deprivation of assets, making the situation even worse. Experts suggest understanding the rules early and exploring legal options, like proper estate planning or structured ownership, before care becomes necessary. The key is not to panic or assume, but to plan with clarity. Ask yourself this: is it worth risking your home based on an assumption, or would you rather know exactly where you stand? If you always thought the house was 100% safe, comment "home" below. Let's see how many believe this myth. We put a lot of effort into these videos, so please take a second to subscribe. It's just one click, but it truly supports our work. Number 6. Not setting up a lasting power of attorney, LPA. This is one of those things people often delay, until it's too late. A lasting power of attorney, LPA, allows someone you trust to make important decisions about your finances, property, and health if you're no longer able to do so yourself. Sounds simple, right? But many families avoid it, thinking they'll deal with it later. Here's the problem. If a person loses mental capacity without an LPA in place, families cannot automatically step in and manage things. Instead, they must go through a lengthy and expensive court process to gain control. This not only delays critical decisions, but can also cost thousands of pounds in legal fees. In real-life situations, this creates stress at the worst possible time. Bills may go unpaid, care decisions get delayed, and families are left feeling powerless. And all of this could have been avoided with a simple document prepared in advance. Experts strongly advise setting up an LPA while the individual is still mentally capable. It's not just about legal protection. It's about ensuring that your wishes are respected and your loved ones can act quickly when needed. Think about it. Would you rather your family struggle through courts, or have everything clearly in place when it matters most? If you didn't know how important this was, comment LPA below. We want to see who's learning something new today We put real effort into creating these videos for you, so please take 1 second to subscribe. It's just one click, but it means everything to us. Number 5. Relying on verbal agreements instead of written proof. This is a mistake that feels harmless in the moment, but can turn into a serious legal headache later. Many families make informal arrangements when caring for elderly relatives. It could be something like, "I'll take care of you, and the house will eventually be mine." It sounds simple, trusting, and based on love. But legally, it often means nothing. The problem is that verbal agreements are incredibly hard to prove. When the time comes for financial assessments or legal reviews, councils and courts rely on documented evidence, not family promises. Without written proof, these arrangements can be ignored completely, leading to disputes, confusion, and even financial loss. In some cases, other family members may challenge these unwritten agreements, it creating conflict and legal battles that could have been avoided. Even worse, councils might interpret certain arrangements as attempts to avoid care fees, especially if assets were involved without clear documentation. Experts strongly recommend putting everything in formal writing, whether it's care arrangements, financial contributions, or property-related decisions. A simple legal document can protect everyone involved and prevent misunderstandings down the line. Ask yourself, would you trust something this important to memory and words alone, or would you rather have it clearly written and protected? If you've ever relied on a family promise, comment agreement below. We want to hear your story. We put a lot of effort into these videos, so please take a second to subscribe. It's just one click. But it helps us keep creating content for you. Number 4. Misunderstanding fair market value. This is a mistake that often happens quietly but can lead to serious financial consequences later. Many families try to transfer assets, like selling a house or valuables to a relative, thinking they're making a smart move. But if that asset is sold for less than its true market value, authorities may see it very differently. Here's the key issue. Councils don't just look at what you did, they look at how and why you did it. If a property worth £200,000 is sold to a family member for £100,000, that missing £100,000 doesn't just disappear in their eyes. It may be treated as deliberately reducing assets to avoid care costs. And this is where many people get caught off guard. Even if your intention was to help family or simplify finances, the council may still classify it as deprivation of assets. This could lead to penalties, delayed care support, or being charged as if you still own the full value. Experts recommend always using independent valuations and documenting every transaction properly. If you plan to sell or transfer assets, it must be done transparently and at a fair price to avoid suspicion. Think about it. Saving money today by cutting corners could end up costing you far more in the future. If this surprised you, comment value below. We're curious how many didn't know this. We put real effort into these videos, so please take a second to subscribe. It's just one click, but it helps us keep bringing you valuable content. Number 3. Gifting property. Too late. This is where many families believe they're making a smart last-minute move, but it often backfires badly. When a loved one's health starts declining, families sometimes rush to transfer property into someone else's name, hoping to protect it from care costs. On the surface, it feels logical, but timing is everything. Here's the catch. Councils don't just look at the transfer, they look at the intent behind it. If the decision to gift property happens when care is already likely or foreseeable, authorities may classify it as deliberate deprivation of assets. And once that label is applied, the transfer may be ignored completely. In simple terms, even if the house is no longer legally owned by the person, the council can still treat it as if it belongs to them during financial assessments. And this can lead to unexpected charges, delays in support, and even legal disputes within families. What makes this even more frustrating is that many people act out of good intentions, not realizing the legal consequences. Experts consistently advise that if you're considering property transfers, it should be done well in advance, not during a health crisis. Ask yourself, are you planning ahead strategically or reacting under pressure when it's already too late? If this made you rethink timing, comment "too late" below. We want to hear your thoughts. We put a lot of effort into these videos, so please take a second to subscribe. It's just one click, but it truly supports us. Number 2. Ignoring the deprivation of assets rule. This is the number one rule that catches families completely off guard, and it's the reason many end up facing huge unexpected costs. The deprivation of assets rule simply means this: if you deliberately reduce your assets to avoid paying for care, authorities can step in and treat you as if you still own them. Now here's where it gets tricky. Many families don't even realize they're breaking this rule. Giving money to children, transferring property, or even spending large amounts unusually fast can all raise serious suspicion. It may feel like normal financial planning, but to councils, it can look like an attempt to avoid care fees. And the consequences? They can be harsh. Councils have the power to reverse financial assumptions, and meaning they can still charge you for care based on assets you no longer have. In some cases, they may even pursue the person who received those assets. What's even more surprising is that there's no fixed time limit. Authorities can look back years and still question your decisions if they believe care was foreseeable at the time. Experts strongly advise understanding this rule before making any major financial move, because once it's flagged, fixing the situation becomes extremely difficult. So ask yourself, are your decisions truly safe, or could they be misunderstood later? If this shocked you, comment "rule" below. We want to know who just learned something new. We put serious effort into these videos, so please take a second to subscribe. It's just one click, but it means a lot to us. Number 1. Ignoring the deprivation of assets rule. The biggest costly mistake. This is the most dangerous and misunderstood rule in UK senior care law, and the one that leads to the biggest financial losses. Many families believe they can simply transfer money, gift property, or reduce savings to avoid paying for care. It sounds like a smart move, but in reality, it can trigger serious legal consequences. Here's what most people don't realise. Councils are trained to investigate intent, not just actions. If they believe you deliberately reduced your assets to avoid care fees, they can apply the deprivation of assets rule and treat you as if you still own everything you gave away. That means, even if the money is gone or the property is no longer in your name, you could still be charged full care costs. In some cases, as authorities may even try to recover money from the person who received those assets. This is where families suddenly face bills they never expected, sometimes reaching £15,000 or more. What makes this so serious is that there's no strict time limit. Decisions made years ago can still be questioned if care needs were predictable at the time. Experts agree, this is not a rule you want to figure out later. Understanding it early can save you from financial stress, legal trouble, and family conflict. So the real question is, are you protecting your assets the right way or risking everything without knowing it? If this opened your eyes, comment "protect" below. We truly read every single one. We put a lot of effort into these videos for you, so please take 1 second to subscribe. It's just one click. But it helps us keep bringing you content like this. So as you've seen, it's not always the big decisions that cause problems. It's often the small, overlooked mistakes that lead to the biggest financial consequences. From misunderstanding the deprivation of assets rule to delaying planning or relying on informal agreements, these are the exact traps that catch thousands of families every year. What makes this even more important is that most people act with good intentions. They're trying to protect their loved ones, secure their home, or pass something on to the next generation. But without the right knowledge, those same actions can be misunderstood, and suddenly, families are facing unexpected costs, legal stress, and difficult decisions. The key takeaway here is simple. Awareness and early planning change everything. When you understand the rules, keep proper records, seek professional advice, and act early, you put yourself in a position of control, not panic. You're no longer reacting under pressure. You're planning with confidence. Take a moment and think, if something unexpected happened tomorrow, would your family be prepared? Or would they be left trying to figure things out during one of the most stressful times of their lives? This isn't just about money. It's about protecting your family, your home, and your peace of mind. And remember, while these insights can guide you in the right direction, always consult a qualified professional for advice tailored to your situation. A little preparation today can save you from major consequences tomorrow.